It is January 4th, 2024. This is date and time set for the front of the court show cause hearing with regard to child support. Mr. Johnson, if you'd state your name for the record, please.
Matthias Johnson on behalf of Daniel Smith, who is also on the Zoom screen.
And Mr. Smith
Dan Smith.
and Ms. Smith.
Marie Carmen Smith.
Thank you. Mr. Hogue.
Jeremy Hope, front of the court. This is the matter of Marie Smith versus Dan Smith, file number 2022-16663-DM. The matter was originally scheduled for hearing on December 7th and was adjourned to today's date. As Mr. Smith requested court-appointed counsel, Mr. Johnson was assigned. Party's most recent order regarding child support is their consent judgment of divorce that requires $147 a month for 2 children. That judgment of divorce has been in place since October 17th, 2022. There have been 2 payments made on the case, a $200 payment in October of 2023 and a $10 payment in July of 2023. There's an outstanding balance of $2,516.50. Of that $2,516.50, $2,436 is owed to the other party. I can pull the payment history up for the court's review.
Thank you. Mr. Johnson, anything you'd like to say on behalf of your client?
Your Honor, unfortunately, Mr. Smith is in very dire financial straits at the moment. He was operating a Christmas tree operation that actually lost money over the holiday season for the first time that's ever happened to him. Additionally, he's about 2 years behind in property taxes. Unfortunately, I just don't know where money is going to come from. What I've discussed with him, I think his frustration is that he feels as though he has the children more than 50% of the time right now, and thus support should be adjusted. If the court is willing to look at that on their own, we would certainly be asking the court to do so. I've also explained to Mr. Smith that that can also be done via filing a motion. His concern with that was the cost to file a motion. I have indicated to him that there are fee waivers for motions that can be procured, and it is something that can be done without hiring an attorney. Unfortunately, I don't think he's hiding any assets. I don't think there's gold buried in the backyard. I think he simply has the inability to pay at this time. I recognize the frustration that this causes upon the other party, not to mention the court in having to enforce this order. But at the end of the day, if there's nothing there, I don't know what we can order him to give. So that is Mr. Smith's position at this time.
Well, he clearly has the ability to work, right?
Yes,
It's not an inability to work. You're claiming it's an inability to pay.
Correct. It's an inability or bad luck as it relates to generation of excess funds over the last year or so since this case came about.
Is he currently looking for work?
Dan, you can answer that question.
Yeah, you can ask him. I'm just asking you because you represent him.
I've got accounts, snowplow accounts, but there hasn't been any snow, and I'm obligated to these accounts if there is snow, and if I don't, it puts me in another situation. And I don't know, this first time, I'm basically all by myself, and I don't have any other sources of income other than it's seasonal. And Christmas trees, the overhead, and I haven't even paid for all the Christmas trees yet. And I owe for property taxes. My house is going to be going up for sale for property taxes if I don't pay it. I'll lose my property. Right now, I've got, I took on all the bills and everything, and loans and everything that we had. And right now, I've got till Sunday to pay on some of these loans, and I don't have, unless some accounts receivable come in, I don't have the money right now.
Okay, if it's true that you've got the kids frequently, what how are you able to support them if you don't have any money?
Their grandma and grandpa have helped me out a lot. They have supported me 100%. And if it wasn't for them, I'd be dead.
Other than the accounts receivable you have and waiting on snow, what's your plan to get through the winter? I mean, are you looking for other work?
Right now, I've got contracts for snow plowing, and then if I'm doing something else, these people that I'm obligated to, and well, the last big snowfall we had, my one plow shorted out and it burned up all my wiring and under the hood, and from there, just to get that replaced was $1,400. And
We've
then
got a really low bill here of $147 a month. So I need to figure out how you're gonna pay that, because it's for two kids, and I've had much bigger bills just this morning for two kids that I'm responsible for.
well, I spent
It's not really an issue for me of, I can't change the order. That's the order that's in place. And it's
Well,
not very
the only
high.
reason-
You gotta get something figured out.
the only reason I signed the order is because my lawyer at the time told me I needed to. And she closed her practice halfway through the divorce. And she didn't really care. She was just basically pushing me through the system. And they didn't account for all my expenses either.
That's not really what I'm here to figure out either. I'm trying to figure out how I can get $147 a month for two kids.
Right now, I've been taking care of the kids while she's working, and all through the summer. And
Because respectively, owing a little over 2,000, it's not that out of control. But when you compare it to a 147, it is, okay. It's a lot of non-payment. So I'm just trying to get you back on track. If
Right
that
now-
makes sense. And if the story is, well, I'm gonna just wait around, then you could wait around in jail. It doesn't matter to me if you're not paying.
at this point,
What difference does it make?
right now, I'm about ready to lose everything. It's been suggested that I go through bankruptcy, or go to Section 8. I don't know. I am trying to see if I can consolidate my credit cards. I'm paying over $2,000 interest every month in all my loans and credit cards and everything. And at this point, I don't know. And she's got her income plus her second boyfriend's income. Her first boyfriend.
All right, Ms. Smith, anything you'd like to add or say?
Well, I just have some ideas. He could scrap all of the scrap metal in his yard, and that
I've
would
already
clean up
done
the
that.
yard.
I've already done that, and
We're waiting on Ms. Smith. We've muted Mr. Smith. It's not an opportunity for the two of you to argue. I'm just trying to hear from everybody and figure out what's going on and see if we can get back on track. Anything you'd like to say, Ms. Smith?
Well, just that the grandma and grandpa he mentioned was my mom and dad. Like, yes, they watch the kids at his house. I guess I really don't know what else to say.
I mean, are the two of you in a position where where you are not operating the custody arrangement as ordered?
Oh, we're following the custody arrangement. We're doing the 50-50.
I am watching them more than 50-50.
Well, if that's true, the two of you will have to take care of that with your caseworker and file something if you're wanting to change it. I mean, obviously, if that's true, the court's not going to file its own motion. So we're not, because I don't know. You have to come to court and prove it if you're not, if the two of you don't agree that that's what's happening. If you agree, you could file something, but I'm not going to take from what is said today and say, okay, well, we're just going to move this. We're just going to change things. Okay. That's just not the way these hearings work. So, sir, if that's true and you want to file a motion, you'll have to file a motion. Mr. Johnson's correct that you could request a fee waiver. It happens all the time. So, you have other options if that's not how you're operating. Basically, this today is going to serve as a warning. Okay. We don't have to talk about jail. I mean, like I said, it doesn't make any difference to me if you're sitting in jail if we're not receiving payment, because it's the same amount of payment coming in. I mean, I want you to be able to spend time with your kids. Obviously, that's very important. So if you are, I'd rather you be at home, sir. But for child support, there's nothing I can do about the order. It's $147 a month. That's not that much compared to, I would say, 100% of the 8 or 9 hearings I've already had this morning, especially for 2 kids. So you're not in a spot to really say, well, it's too much. It's not very much. And the only reason I suspect why your arrears isn't very high is because of your monthly obligation is so low. So I'll adjourn this out 60 days. I want to see payment paid current, meaning the 147 for at least 2 months. Maybe you'll start thinking about looking for a different job. But the thing is if there's nothing I can do with one, sir, I'll just tell you, obviously we've confirmed on the record you have the ability to work. So there's not really a reason why you're not. And that's where I'm trying to figure this out. And I'm trying to work with you, except you're just telling me what your plan is to wait around. And unfortunately, I can't do that. I have an order. I can't just wait around either. I have to enforce the orders as they are. And this was a consent judgment. So you did agree to it. You've had knowledge of it. So this is sort of a warning. If we're here in 60 days and we're doing the same exact thing, you're not leaving with me. You're not leaving me with many options. I will discharge Mr. Johnson from the case. If Mr. Smith, if you wish to request an attorney to represent you at the next one, you'll need to make that request known either before or at that time. All right. Thank you all.
Thank you.
Mr. Hogue.
I just have one quick question, Mr. Johnson and or Mr. Smith. Mr. Smith just indicated on the record that he has over $2,000 a month in credit card obligations that he's paying. How is he paying the over $2,000?
Well, I've already adjourned. I'm not asking them any more questions.
All right.
This is a warning for him. He knows that if he comes back and hasn't paid anything, he'll likely be in jail. So
right.
Thank you.
Thank you, Your Honor.